thank you to all of our listeners for joining this webinar, and also to Savvy Ladies for hosting me. I really appreciate it. So let's go ahead and get started. Estate planning, the best gift you can give your family. So do you have an estate plan? And if not, why not? I'm guessing many of you are on the call because you don't have an estate plan. You're thinking, why would you need one? How can it help your family? And some of the common objections that I hear, the common reasons that people sort of avoid doing an estate plan or keep putting it off. One of the superstitions is that planning for death will hasten its occurrence. I hear this one a lot. People are afraid that getting a plan in place will actually, bring death upon more quickly. I don't have time. A lot of people think, it's going to take too long. I don't have the time or the energy to deal with it right now. Another objection that I hear is that I'm not old enough, I'm not wealthy enough, I don't have enough money. This is a really common objection as well. But the good news is that I've never actually had a client pass away immediately after signing their estate plan, so you should be in good shape. And really, you owe it to your family and to your loved ones to make sure they're protected. Again, it's not fun thinking about putting an estate plan in place, but really it is a gift to your family and to your loved ones. And then finally, as you'll see as we go on throughout the seminar, estate planning will help you no matter what your age, what your wealth. In fact, sometimes I think that estate planning is more important for people who have minor children at home, younger families, because when you have minor children at home, you need to be thinking about what kind of guardians you'll name in the event, that something happens to you. So I think that's almost more important than having a plan in place when you're older and you're thinking about how you want to pass on your assets. So estate planning is beneficial regardless of how much money you have, regardless of how old you are, and you'll see as we go through. So I'm guessing that you're on this webinar because you have someone or something that you care about, you want to protect, you want to make sure that your kids are taken care of no matter what in the event something happens to you. You want to make sure that your assets are passed in a certain way. You want to make sure that you're not losing assets to unnecessary taxes or lawyer fees. And so those are all really good reasons to be here, and you're definitely in the right place because we'll talk about all of those things. So just a little bit more about me before we get started. That's me, and I have a prior career as a CPA. I worked at Ernst & Young and Goldman Sachs before law school, and then went to the University of Minnesota Law School. And as Maggie said, I practiced for several years doing estate planning at a bigger law firm as well before I decided to open my own practice. So let's talk about what an estate plan does. What actually are you getting out of having an estate plan in place? And it not only provides for things to move a certain way at your death, but it also helps you make decisions during your life as well. So it provides for, it lets you make decisions for you and your loved ones during a period of disability. So many people will actually become disabled at some point in their life and not able to make decisions about their health care and their finances. And when you have an estate plan in place, you've made decisions about who you would want to manage those affairs for you. If you haven't named someone to manage those affairs for you, a court has to get involved, and that can be very expensive. So an estate plan lets you leave the assets that you have to the people that you want in the way that you want. And this is important, regardless of how much money you have. I think, we all care about the things that we do have, and we care about them being passed to the people that we want in the way that we would want. And estate plan is great in the sense that if you work with a lawyer, they're going to help you figure out ways to minimize or completely eliminate things like estate tax. There are ways that you can structure your estate to avoid probate, and we'll go through that here in a second, which will save your family a lot of money and time when you do pass away. And you can structure things to minimize court costs. So an estate plan will do all of those things. Estate planning lets you share your hopes and your dreams and your values with your loved ones. We call this legacy planning. So it's passing on your intangible assets, the things that you really care about, your stories, your insights, your experiences. You can support the causes you care about most with an estate plan. This is charitable giving. And again, one of the big ones is naming guardians for your children if you have minor children at home. So estate planning is a really smart investment. One of the big things that people do with an estate plan is they structure it so their estate bypasses probate when they pass away. And we'll go through why this is important here in a couple of minutes. But the main point for this slide is that probate is actually pretty expensive. It costs about 5% of your estate that your estate will be paying to lawyers to sort of push your assets through the probate process, which is a lot of money, and it's not necessary. You can structure your estate to avoid that. Again, you can structure your estate to avoid or minimize estate taxes, both federal and state. The estate planning attorney is going to help you make income decisions that will have positive income tax repercussions as you move along. If you have an estate plan in place, it's very unlikely you'll have these, infighting among the family. If you've made your wishes known, it's just not as likely that people are going to be fighting about who gets what, and that can be expensive as well. And again, an estate plan will eliminate the need for expensive court intervention if you become incapacitated and you cannot manage your health decisions or your financial decisions, or if you haven't named guardians for your kids. Because, again, if you haven't gotten these documents in place and something does happen, a court will need to get involved to make the decisions for you, and that ultimately ends up being really expensive. So if you pass away without an estate plan in place, the state of New York has a plan for you, basically. It's called the Laws of Intestacy, and these are the laws that the state has determined if you don't have a plan and you pass away, this is where all of your assets are going to go. So your assets will not be distributed the way that you would have wanted. They'll just go according to whatever the state law is. A judge will name guardians for your children, which I think is something no parent really wants. You pass away without your estate plan, your estate is guaranteed to go through probate. And again, we'll talk about this in a second about why that's bad. Your assets that you pass down to your children, if you don't have a plan in place, they won't be protected in any way against lawsuits or bankruptcy or divorce. These are things that a lot of people want to protect the inheritance that goes down to their children. And if you don't have a plan in place, there'll be no protections on any of those assets. And everything will go outright to your kids at 18, which is also something that most parents don't want. So if you're a parent and you're on this webinar, I'm guessing one of the most important things for you is you're thinking about how you can name people who will take care of your kids in the event something happens to you and your partner. So again, as I said earlier, you name guardians in a will, and this is the document where you specify who you would want raising your children if something happened to you. And if you don't have a will and you haven't named guardians, a judge will actually end up making that decision for you. And a judge is obviously a complete stranger. They don't know anything about your family, the relationships in your family. They'll just be making the best decision that they can based on the information they have. So it's expensive, it's time-consuming, it's difficult for the family. And again, a judge might end up picking the last person you'd ever want raising your kids. So the solution to all of this is to have a will in place where you can name your guardians of choice. So when it comes to distributing your assets, there are two main options that I'm going to go over. And as we're going through, you should be thinking about which option you think makes the most sense for your family situation. The first option is just a last will and testament-based plan. Just everyone knows what a will is. It's a document where you list who you want to get your assets when you pass away. You name guardians for your kids in a will. You name an executor for your estate. So this would be the person who would guide your assets through probate on your behalf and distribute everything for you. These are the main things that a will does. There are a lot of things that a will doesn't do. There are a lot of disadvantages to having just a will in place. One of the things that I mentioned earlier is that if you have a will in place, everything will go down to your children if that's what you want, but it'll go outright at 18. So outright means there are no protections on those assets. They'll just get a big check on their 18th birthday, which most parents don't want. But if you have a will in place, and only a will, there's no way to avoid that. There are no protections on the assets that go down to your children if you just have a last will in place. They're not protected from creditors or your daughter's future ex-husband. They just get them outright, and that leaves them very vulnerable. You can't do any incapacity planning in a will. So as I stated earlier, in the event that something happens to you, you're incapacitated and are unable to make your wishes known regarding your health care and making your financial decisions. You want to have documents in place that name people to make these decisions for you. It's called a power of attorney and a health care proxy. You don't name these people in a will. You have to have separate documents to name those people. You can't really make any final disposition instructions in a will. Many people have very specific concerns about whether they're buried or cremated, and they really want things to happen a certain way. You have to document that in a document outside of a will. A will won't let you do any tax planning or tax avoidance planning at all. So you may not have a taxable estate, and we'll go over that later on in our slides. But you can't really do any tax planning or any kind of financial planning at all in a will, which can be very costly if you have a bigger estate. A will doesn't let you put any conditions on the gifts that you leave. So sometimes people want to leave a certain dollar amount to some, maybe a niece, but only after she's finished her 4-year degree, something like that, conditions like that. And you can't specify those wishes in a will. You can't leave money for pets in a will either. You've got to do this kind of planning outside of a will as well. If you have an heir who has special needs, this is a special kind of planning that involves probably a special needs trust. So you would want to do planning on top of just a simple will if you have any heirs that have any special needs. And the biggest disadvantage to your assets passing through a will is that they're guaranteed to go through the probate process. So this is a common misconception. Many people think that if you pass away and you drafted a will, that means that your estate bypasses probate because you've said in a document where you want everything to go. So why would a court need to be involved? But a last will actually guarantees probate. So if you pass away without any planning, and if you pass away with a will in place, your assets are going to go through probate upon your death. There's a way to get around it, and we'll talk about that a little bit later in the presentation. So what is probate, and why is it bad? So probate is the court-supervised process of authenticating a will if the deceased has made one, and distributing your assets according to the instructions in that will. So it would include locating all of your assets, determining their value, and distributing everything to the people named in the will. So probate is bad for 3 main reasons. First is that it's very expensive, it's time-consuming, and it's a public process. So we'll go through each of those individually. So just to get a sense for how much probate is going to cost your heirs, and when I say how much it will cost, I mean how much your estate will be reduced by when you pass away. So this isn't a cost that your heirs are going to have to bear. They're not going to have to write a check out of their personal account. This is just how much your estate will be reduced by if it has to go through the probate process. So just a quick example, if you imagine that you have real estate, the market value is $800,000, which in New York is not unheard of, and then cash and some investments worth $200,000. So you have a total probatable estate of $1 million. The standard fee that attorneys charge when they're moving assets through probate on behalf of an estate is 5% of the probatable assets. That's just a standard fee. Sometimes it's a bit more, sometimes it's a bit less, but that's the average. And so in this case, that will be $50,000. So in this example, if you pass away and you have no estate plan or you have a will-based estate plan, your estate's going to be reduced by $50,000, lost to lawyers who are probating your estate, which is, I think, is a lot of money. So it's very expensive. Probate takes a long time. It takes 7 months minimum in the state of New York, usually 12 to 18 months before everything is settled. That's just how long it takes to move all of your assets through the court process. There are no access to your assets during that time. So if your heirs are relying on any of those assets, they're not going to be able to access them until everything has gone through the court process. And this can take longer if there are any family disputes, which frankly are quite common. So that would just drag out the process even longer. And the only people who really benefit from any kind of dispute are the lawyers, frankly. So it takes a long time to push an estate through probate, and that can be a problem. Probate is a public proceeding. Wills are public records. So this is kind of interesting, I think, because many people, when they draft their wills, they think of it as, a very secretive document, and they don't want anyone knowing what they've put in their will. But then when you pass away, your will is actually filed at the courthouse, and anyone can go down to the courthouse and look at people's wills. You can look at, celebrity wills, and any will that is down there is a public record. So it's kind of ironic, I think, that that's the case. And so if you don't like the idea of people, someone looking through your will when you pass away, a will-based estate plan is not for you. In fact, it's known that predators, people sort of preying on children who might come into money at 18, they go down to the courthouse and they sift through people's wills, and it's, they have very bad intentions. So probate is a public process. So again, I just wanted to make it clear that a last will guarantees probate. If you die without a will, you'll have to go through probate, and if you die with a will, you have to go through probate. So the good news is that you can avoid probate with proper estate planning. So if this sounds to you like something that you think makes sense to avoid, you can definitely structure an estate plan to avoid the probate process. And the way to structure your estate plan to avoid probate is by setting up what's called a revocable living trust. So there are a lot of different kinds of trusts, and they all do completely different things. So it's important to remember that as we're going through. Some trusts are set up to minimize an estate tax liability, and some trusts are set up to structure how your children are able to access the assets that you've left behind. So there's lots of different kinds of trusts, and they all do different things. The only thing that a revocable living trust does is it allows your assets to bypass probate. So it doesn't protect your assets in any way from creditors. It doesn't save on estate taxes or any kind of taxes for that matter. It doesn't do anything other than ensure that when you pass away, your estate will bypass probate. So what is a revocable living trust? A revocable living trust agreement is basically just like a will. It's a document that says where you want your assets to go, just like a will. And what you do when you set up a revocable living trust is you retitle your assets into the name of your trust. And this is what allows these assets to bypass probate. So when you retitle your assets into the name of your trust, you're not losing ownership of them in any way. You can still sell those assets. You can take them back out of the trust. You don't have to set up any kind of a separate tax ID number. The IRS doesn't know about your revocable living trust. you simply just retitle your assets into the name of your trust, and you'll give your trust a name. And that will allow those assets to bypass probate when you pass away. It's a revocable trust, which means it can be revoked or amended at any time. Not all trusts are like that. Some are irrevocable. And then what it allows is when you pass away, all of your assets are distributed according to the terms of the trust, just like a will, except it completely bypasses the probate court. So there's no court involvement when you set up a revocable living trust. And that's why people do it. It's set up simply to avoid the probate court when they pass away. So if you remember this slide, the cost of probate, this is the amount of money that your heirs would save by setting up a revocable living trust instead of just having a basic will plan. Now, there are some attorney costs associated with a revocable living trust, but they're much, much less than the 5% that I've listed here. So it's a pretty smart investment for many people. Other advantages to a revocable living trust are that the assets are distributed much faster because they're not stuck in court. Again, the court is not involved in any way. And your affairs will be settled in the privacy of an attorney's office. So your heirs will hire an attorney to help distribute the assets in the trust for a much lower fee, and it'll happen in the privacy of an attorney's office, so nothing will be public. No one will know what your wishes are. So just a quick summary, those are your two estate planning options, and when you're thinking about your own family and your own assets, this is the way that you want to think about how you want to structure your plan. So your children's inheritance. Many parents don't like the idea of their children's inheritance being given outright at 18. Even if you have the most responsible children in the world, it still isn't a good idea. Without any estate planning in place, that's exactly what will happen. The money that they receive can be spent or gambled away. It could be stolen, lost to creditors, lost to bankruptcy, lost to a divorce. So this would mean your daughter's future ex-husband might end up with half of your, hard-earned IRA, which I think most people kind of cringe at the idea of that. So this is not what I would recommend in terms of leaving your money down to your children. And again, it's a risk even for the most mature and responsible 18-year-old because, again, people are often sued for, innocent mistakes and, or divorce, something like that, doesn't reflect on bad character. It's just life, but these assets are not protected in any way from those things. So the solution to leaving your assets outright to your children at 18 is leaving them instead in what's called a lifetime asset protection trust. And this document or this trust is completely different from the revocable living trust that we spoke about earlier to avoid probate. This is a trust that comes into place after you pass away, and it's a trust that you set up so that your children's inheritance can be more protected. So what it does is it protects your children's inheritance from lawsuits, bankruptcy, divorce, the things that we were just speaking about. But it makes those assets available to your child for anything like health or education, maintenance, and support. So what falls into this category would be any medical bills that your child has or any college tuition payments, a down payment on a home, a first wedding. So the funds will be available for your child for all of the things that you would want them to be able to access those funds for. Tuition, healthcare, that kind of a thing. But at the same time, they're protected from things like lawsuits, divorce, etc. So in many ways, it's really the best of both worlds because the funds are protected, but they're also available. So what you would do with a lifetime asset protection trust is you would name what's called a trustee to oversee the assets in this trust, and that will be someone that you know and that you trust and that you think would make good decisions. It can be someone in your family. It doesn't have to be. And that person would oversee any withdrawals from the trust for your child for health, education, maintenance, and support. Now, the good news is you can actually name your own child as co-trustee of their own trust and at a certain age, and also as sole trustee of their own trust at a certain age. So the point being, when people hear the word trust, they think, oh my gosh, I'm not going to be able to, access those assets. They're going to be tied up. If your child is co and then sole trustee of their own trust, they're really going to be able to access those assets for all the things that you would want them to be able to access them for. So a lifetime asset protection trust is an option, whether you have a will-based estate plan or a revocable living trust plan. This is something that's available under either plan, because the only difference between the will-based plan and a revocable living trust plan is that one plan avoids probate and the other one doesn't. But the lifetime asset protection trust is dealing more with, what happens once your assets go down to your kids and what kind of protections there are in that case. So I want to talk very briefly about estate taxes. So estate taxes would be a tax that your estate would have to pay upon your death. The taxes would come out of your estate. It wouldn't be something that your heirs would have to pay. And it's a very high tax rate. So it's about 45% of whatever dollar amount is above the exemption. So what that means is if you're single and you have assets that are more than about $5.5 million, you right now would want to plan to avoid estate tax, because you would have to pay estate tax 45% on any assets more than $5.5 million. The same thing if you're married, except the number is 11 million. So most people at this point do not have an estate tax concern. Only people who have assets greater than these numbers. A couple of things I'd like to point out is, first of all, the estate tax actually may go away altogether under some of the new tax legislation that might be pushed through. So in that case, nobody would have an estate tax concern, regardless of how much money they had. So these numbers, the point being, these numbers change. A couple of years ago, these numbers were as low as $2 million. So anyone who had an estate over $2 million had to plan to avoid estate tax. So the thing to keep in mind is these are the current numbers. The numbers change. They will change again at some point in time. And you want to make sure that you have a relationship with an estate planning attorney who keeps on top of these things and will be in touch with you if it looks like your estate is going to venture into the estate tax range, because it can be an incredibly expensive mistake if you don't realize you have a taxable estate and then you pass away and you end up writing a big check to the government that you could have completely avoided if you had planned otherwise. So I want to talk a little bit about online documents. I get asked a lot why people can't just do their estate plan online. And it's a really valid question. I completely understand why people would ask this, especially because many people, they think they've got a relatively simple estate. How hard can it be just to sort of do it online? I wouldn't recommend doing an estate plan online, and I'll go through some of the reasons here pretty quickly. An online estate plan, it's going to be very easy to make errors or omissions. Even if your situation is not complicated, it's really easy to make an error or omission, and even the smallest, mistake or omission from your will can have really bad consequences, really expensive consequences. I like the example of the former Chief Justice of the Supreme Court, Warren Burger, actually drafted his own will, and he messed it up, and it ended up that his heirs had to pay $500,000 in taxes that they wouldn't have had to have paid if they had planned properly. So, if a Supreme Court justice can't get it right, it's not something that you want to try on your own. there are a lot of formalities with executing estate planning documents. They have to be signed a certain way with certain witnesses, and the court is very picky about these. Most people don't realize that they have to be signed and executed a certain way. Every state has their own rules, so a cookie-cutter will is not a good idea. You're not going to be able to do any tax planning with an online document. If you have any kind of a blended family, so any kind of children from a prior marriage or a second marriage, that makes planning pretty complicated right off the bat. So that's not something you want to try to do online. Many people don't realize that the beneficiaries that you've named on things like life insurance or your retirement accounts override what you've written in your will. So what that means is if you say in your will, I want everything to go to my sister Amy, but your beneficiary designation on your life insurance is going to your brother Tom, the life insurance is going to go to Tom, despite the fact that you said in your will you want everything to go to Amy. So everything has to be coordinated. When you're working with a lawyer, what you're really paying for is not necessarily just the documents. You're paying for counsel and advice as well. And you'll probably end up spending more money in the long run trying to do it on your own, because you'll probably have to fix it. In the meantime, you can make a lot of costly mistakes. So if you're interested in moving forward with an estate plan or wondering what the next steps are, I invite you to join me at my office. We give free estate planning seminars at my office, and it's different from this webinar in many ways. We'll go over estate planning as well. There'll be some educational material, but we'll also review my estate planning packages and our 3-meeting process. I go over my fees in detail. So one nice thing about my office is that all of our fees are flat, so we don't do any billing by the hour. So you know exactly how much you're going to be investing in your estate plan, and there aren't going to be any surprises. And there's always time for Q&A at these seminars as well. And then if you mention this webinar, you'll get a free copy of the best-selling book on legal planning for busy parents. So this is a really great book that kind of goes through examples in a choose-your-own adventure style that makes it, really clear how things can go wrong and how planning can make things better. So you can save your seat on my website under the Events tab, and this is the website, and you'll be getting an email, I think, as well with this link, so you can reserve your seat for our next seminar. And if you have any questions, also feel free to reach out. My contact information will also be sent out via email. So again, if you're interested in moving forward and learning a little bit more about how your estate plan you can get started on your own plan, I recommend that you register for one of our free webinars. So thank you.
Thanks, Laura. That was great. I just want to remind everyone, if you have a question for Laura, you can use the chat box or you can email info@savvyladies.org. And I know we had some questions come in during your presentation. So we'll get started with the first one here. Is there any maintenance involved with a revocable living trust? Do I need to be making any updates to it over time?
Yeah, that is a really great question. I'm glad that someone asked that. So the short answer is no. Once you draft your revocable living trust document, you don't need to maintain it. You don't need to update it every year. It's just drafted and it just remains the way it is. The one thing you do have to do with a revocable living trust is as you acquire new assets in the future, you'll want to make sure that you acquire them in the name of your trust so that they avoid probate. Like I said earlier, you have to fund your trust, and so initially you fund your trust with your current assets and you move those into your trust. And then when in the future, if you buy a house or if you acquire a new checking account or something, you'll set that up into the name of your trust. But there's no annual maintenance or anything like that goes along with the revocable living trust.
Okay, thank you. The next question is, can the Lifetime Asset Protection Trust also be used for an adult child? Would the adult child be named the sole trustee?
Yeah, so the Lifetime Oh, pardon? Okay, yeah. Yes, the answer is yes. The Lifetime Asset Protection Trust stays with your child throughout their life. So your adult child could be named, you can name them as a co-trustee, say at age, 30, and then maybe a sole trustee at age 35. But that's why it's called a Lifetime Asset Protection Trust, because the funds are always in the trust. I hope that answers that question.
Okay. Yes, thank you. Another question is, I'm concerned that my grown children will argue over my estate. If I establish a revocable living trust, is anyone allowed to dispute it? Can you just talk a little bit about issues that might come up afterwards?
Yeah, so people can dispute estates, but it doesn't happen very often. And if you have an estate plan in place, it's going to be very unlikely that your children will have any sort of standing to make any disputes. That's the whole point of putting an estate plan in place, is saying this is where I want everything to go. So I would recommend you put a plan in place, you make it clear who you want to receive your assets, and then there's no kind of standing for your kids to make any to complain about it. And the other thing I would say too is that there's actually a specific provision in a will under both the will plan and the living trust plan that basically says if anyone who's receiving under this plan makes any complaints, then they're automatically disinherited. So that basically discourages anyone from making any kind of a complaint, if that makes sense. So you can draft that into your plan saying, if you're my daughter and you're not happy with what you got under my will, and you take an action with the court to complain about that, my will is saying that you're just automatically cut off. So you can do that, and it discourages people from it. It discourages disputes among heirs, is what it does.
Mm-hmm. Okay, good to know. And I believe this is the last question we have. Are you able to give a cost range of creating these trusts? Is it based on assets, or is it more of a flat fee or an hourly rate?
Oh, yeah. So that's a great question. So it is not based on assets at all. It's a flat fee, and the fee is not any higher if you're married or if you have children. So nothing is billed by the hour. So when you come to one of my seminars, I'll go over my fees in detail. But basically, a will-based plan is kind of the lowest amount. If you decide to do a revocable living trust plan, that's a little bit more expensive. And then we have a plan in place that is more expensive, and it allows, if people choose the highest plan because they want me to fund their trust for them, some people just don't want to do it and they're willing to pay me. So that there's a range of fees, but they're all flat. Nothing is billed by the hour, and there are no surprises. So when you have questions going forward and you want to email or call, you can do that as much as you want without getting a bill in the mail. But I go over my fees in detail at my seminars, so I would love to see all of you at one of my upcoming seminars, and you'll get all the tools that you need to make a decision to move forward at my seminar.
Okay. All right. Well, I want to thank you, Laura, for an excellent presentation, and thanks for so clearly explaining everything today. And we will be sending out the link that Laura had for events, so you'll be getting that soon. I also want to thank everyone for joining us today and asking questions. We hope you'll be joining us again. So thanks so much, Laura.
Thank you very much. Thank you to all the listeners as well. Have a great day.
You too. Bye-bye.